Danse Noako Mangante. Shay Yellowbird Nisigasan. Nisikopako Jinia. Gakio Kitagasko Dinawao. Hello everyone, my name is Shay Yellowbird. I currently sit on council for Samson Cree Nation, and I want to welcome you all to this video. I know I had some nation members reach out to make another video around our proposed election law amendments. So that's what the purpose of this video is going to be. Now, before I get into things here, I'll share with you. So if you recall, first made some posts back in August around these proposed amendments that were discriminatory around age. At that time, there was information sessions and there was supposed to be a general meeting called in early September. It was delayed, or it has been delayed now, to get a legal opinion. I don't think it's actually been reviewed by a constitutional lawyer, which I would like to see, because there's unconstitutional amendments on this and human rights infringements. But I'll get right into the mix here. So there is a general meeting being called. They keep changing the dates now, so it's now November 7th. Proposed changes to our election law will undermine Aboriginal and human rights by age and language discrimination, voting barriers, and will undermine administrative oversight in elections and tribunals, and reduce Aboriginal informed consent while increasing manufactured consent, making it harder for members to participate in our elections. So I would encourage members to show up to this general meeting, vote some of these amendments down to protect you and your children's rights, past, present, and our future. So what do I need to know? That this general meeting will actually change written election laws for all membership. These changes should happen via referendum vote, not a general meeting, to allow more member engagement. And my previous post on this, it's almost like a loophole of sorts. They're using part 23, which shows that only a majority of nation members need to be in attendance to call a vote for amendments. So this is updated. This was the previous one. It should say November 7th. You should show up on November 7th now to protect your laws. So number of the laws proposed. Number one, right now, only 1 out of 6 SCN members can speak our Cree language. Discriminatory new law would ban the majority of nation members, 80%, from running in elections if they don't speak Cree. This is inequitable language discrimination causing political discrimination. We should be incentivizing our people to speak a language that was stolen, not penalizing them economically and politically with prejudice laws. 2, current SCN law allow all adult members 21 and over to run an election. SCN is proposing to change the minimum age to run for chief to 40 years old. This is not only a Charter of Freedom of Human Rights infringement, but violates our tribal law, which acknowledges elders, women, youth, and members involved in collective traditional government. Majority of our voting members are under 40, making 67% of the voting population. Allowing them to vote, but taking their right to choose a younger candidate goes against democracy and the right to choose. 3, our SCN written law acknowledges the overlapping jurisdiction of SCN law with Aboriginal law and human rights law. However, new laws are being proposed to give SCN, quote, sole jurisdiction, end quote, over election law, with another law that candidates must accept the outcome of SCN tribunals as final. This means that if candidates are unlawfully removed, as in my case, or if unlawful or politically biased election tribunals occur, SCN is trying to undermine our right to challenge the tribunal result in the court of law. This undermines Aboriginal civil and human rights, such as the right to a fair trial or the right to administrative accountability. So Aboriginal rights are not a veto against international human rights law or the right to a fair and legal administration of tribal law. 4, currently the cost for SCN members to run an election are $1,000 for chief and $500 for council. Proposals are being put forth to increase the rates to $1,500 for chief and $750 for members to compete and run an election. Unemployment on the reserves by 80%. This new policy would make it more expensive for our disadvantaged members to participate in our elections, unless, of course, perhaps you are already in office or on banned payroll. 5, referendum law allows consultation, transparency, and engagement with the people. Under Wagotoin, we are all one, and that requires a duty to consult. A general meeting is called where only a majority of nation members vote in favor, which does not specify how many may be present. It is not reflective of the people's electoral vote. Importantly, this is a loophole around referendum laws and breaks that duty to consult members at large. In addition, SCN is proposing that 50 people must show up to vote at the general meeting. In order to change that SCN tribal laws for everyone, it's important that you are informed and show up. So the election law, new proposed policies violates human rights, Aboriginal rights, would only compound barriers for elders, women, youth, and members, undermine economic, social, political, and language rights of our people. Part of decolonization means liberating our people to make it easier, not harder for Samson Cree peoples to participate in a democracy while having their individual rights, collective tribal laws upheld. 6, currently, our SCN laws have our SCN election law has the SCN election committee oversee elections, election tribunals, and election appeals. They're now proposing to replace the election committee with a new Ona Ganahitjigeo election commission. SCN members are supposed to vote on all laws, which the SCN election committee is governed by. However, SCN is proposing that the Ona Ganahitjigeo election commission be approved and be governed by a new section H. So currently our law only has section A to G only. So section H, the terms of reference, was not included described in that change proposal that's being presented to the people in these information sessions. However, the board has seen it. The omission from this election law recommendation sheet to the public reduces transparency, informed consent, and the right to a fair amount of time to evaluate. So SCN treaties and laws are living documents. You own and vote upon our laws. Having that open access to those laws is important. So you got to remember that SCN works for you, not the other way around, and that we need to protect that informed consent and reduce manufactured consent. 7, currently voting for chief and council occurs with in-person ballot voting in Samson Cree Nation, Pigeon Lake Reserves from 9 a.m. to 9 p.m. on election voting day, with online voting from 9 a.m. to 9 p.m. All other voting locations are open 9 to 6. New laws are being proposed to alleviate the Pigeon Lake voting stations and increase virtual voting. We should be increasing accessibility, but not at the cost of in-person voting. In addition, there has been no definition of virtual voting, which warrants review with fair time to evaluate. So 8, in addition, SCN has proposed that members running in elections are subject to a new code of conduct in elections law, which is to be voted on by members. However, there is no description of the code of ethics in the proposed amendments. So virtual voting may be increased, but in-person ballot voting cut, which reduces accessibility for many people. First Nations governments have a duty to accommodate for individuals and families without internet or those who do not know how to use them, like many elders. So I encourage everyone to come out to protect voting rights and protect the election rights. So new laws, new policies will discriminate against off-reserve members from running in elections, even if they live in Treaty 6. Number 9, currently members living within 100 kilometers from Samson Cree Nation or Pigeon Lake Reserve in Treaty 6 territory for 6 months prior to an election have the right to participate in our elections. So new amendments are being proposed, which will only allow members who live on reserve for 6 months preceding an election to run our elections, even if they live in Treaty 6 territories. This further creates barriers for members to participate in self-government. Moreover, many members move away from work opportunities or education development. First Nations experience a brain drain with policies that reduce opportunity for First Nations to equitably include themselves. I believe it is better to allow members who live in Treaty 6 the right to run, contingent on them living close enough to commute or move once elected. Discriminating against our own Treaty 6 members and disadvantaging them is a colonial ideology. hinders decolonization. So reconciliation means fostering opportunity for leaders onto the red road home. 10, free, prior, informed consent. SCN members own the Elections Act. You gotta remember that the Elections Act is your property, not just the property of chief and council who are elected to serve you. The SCN election laws were taken down for some reason, and leading up to this election on the SNN website, I have them on my personal counselor site to support your Aboriginal right to informed consent. Take a peek on this website if you want a copy of the election law. There should be a little drop menu there. You can click on it and download it. About 70 pages. So I was just highlighting the transparency, legal terms, support, informed consent. This is what was missing. That was these legal definitions that we just went through. There was missing the terms of reference, code of ethics, legal description of virtual voting. So Aboriginal, free, prior, informed consent, know all your rights before you give them away. So these are just a table of the proposed policies, 1 to 10. You can pause the video and you can look at it. These are links for the general meeting. Like I mentioned, they keep changing it, pushing it back. I would actually like to see just wait till the next election, seeing how we're so close to one now. Don't see why there has to be changes that are so close, which could actually put the nation in a vulnerable position with human rights infringements and unconstitutional amendments. Decolonization means honoring our sovereign rights. It means upholding consensus in tribal government. It means protecting Aboriginal individual rights to liberate our members and includes developing physical, social, political, economic opportunities to empower self-determination, people, and way of life. It's been working for you to protect informed consent from manufactured consent. So here's the judicial review I had filed. So this the judgment came in favor in 2021. The judicial review of the SCN Election Commission, it actually upheld sovereignty of the people's vote. This is what I was trying to share on the radio recently. I got censored by the chief, so on that constitutional issue, which was pretty ironic considering freedom of speech is a constitutional right. So but it also demonstrated a need for Aboriginal law oversight in the election law. So this is what the federal judge Gramon, to summarize, while I recognize that our court should show deference to election appeal boards and must nevertheless be satisfied that the board's decision complies with the relevant legal constraints. Valabov at paragraphs 101, 108, 120. Here, the wording and structure of the relevant provisions of the SCN election law constitute inseparable arguments establishing a legal constraint that the board could not ignore. They give the quote knockout punch, end quote, to the board's reasoning. Quotes another quote here, or another case, sorry, Mason versus Canada. So as the Supreme Court said in Babalov at paragraph 121, the board's quote responsibility is to discern meaning in legislative intent, not to reverse engineer a desired outcome, end quote, from section 38. So section 35 says the board implicitly recognized that it needs to fit the situation in one of the categories, even though the breach does not lead to calling a new election. As what happened in my case, section 3027, the board characterized Mr. Yellowbird's breach of section 4.1 as grounds of ineligibility. So in my view, that was unreasonable, as it cannot be reconciled with the language and structure of election law. Yeah. So I remember that. That was when they tried to say I couldn't run in the election for my spot, which was unreasonable because they weren't they pretty much just made up their own interpretation, which the judge says you can't do that because he's the top here. You can't just reverse engineer a desired outcome. and it was unreasonable. So given the above, I need not to decide whether the board acted reasonably in deciding to hold a by-election for Mr. Yellowbird's seat and to prohibit him from running that by-election. Section 39, so 40, as the board's decision is unreasonable and must quash it. Section 22, obligation was on the employer, not the employee. Follows that Mr. Yellowbird's election is valid and the subsequent by-election is invalid. He must be reinstated in his position. Mr. Yellowbird has not yet asked for further specific declarations in this regard, and I trust that Samson Cree Nation will act accordingly. So now we get into the sole jurisdiction proposed in the elections, appeals, and tribunal results. So the current law says that now, therefore, the members of Samson Cree Nation hereby confirm the custom election code called the Samson Cree Nation Election Law, and Sikopok Law Wiasuwin, consists with the existing customs and traditions with respect to the establishment and selection of the chief and council. And the proposed law or amendment is whereas the laws for the Sikopok Inawak of Samson Cree Nation to exercise their inherent indigenous treaty rights to self-determination and implement their customary law to the elected chief and council, according to NNW Sikopok Nawasuin Wiasuwin Nawas-Niguin. So this law, this is the part, has sole jurisdiction over elections. See, they kind of just felt like just threw that part in there, sole jurisdiction. So that translate can elections results can be deemed final, thus extinguishing the right to fight for admin accountability, Aboriginal rights, human rights in court, if it is unfair or unlawful procedures occur. Again, as in my case. So our election law should uphold Aboriginal and human rights law. So the current election law states that whereas Samson Cree Nation recognizes that case law impacts the Samson Cree Nation's obligations and law, and these changes have been taken into consideration in preparing the Samson Cree Nation election law. It's from the preamble on page 1, paragraph 4. And the Vavilov decision, this was what was referenced in my case from the Supreme Court around reasonableness. States that all First Nations have a right to conduct their own elections, appeals, and tribunals. However, all Aboriginal persons have a reserved right to challenge their own First Nations government if unlawful or arbitrary conduct occurs from their own administrations to protect fair elections and trials. Therefore, SCN does not have, quote, sole jurisdiction, end quote, but rather intersectional jurisdiction like every other First Nations and Canadian government and organization in Canada. We're all accountable to Aboriginal human and civil rights law. And it's highlighted in the Charter of Freedoms under Section 11, right to fair trials. Here's all the different Aboriginal and human right intersectionality. Treaty 6, UNDRIP, Aboriginal rights under Section 35 of the Charter, Aboriginal rights under Section 25, Charter of Freedom, Section 3, Democratic voting rights, Section 11, right to fair trials, Section 15, equality rights, Section 16, language rights, Section 24, right to court remedy for the denial of any charter infringement. Just mentioned 25, Section 26, civil and political rights, international human rights duty of accommodate. So I just added this slide in because around when the judgment came down in 2021 March, and you still hear it in the community, was that it violated sovereignty, which is actually false and misleading. And actually, it upheld the sovereignty by upholding our election law. This was a message I was trying to share on the radio with many of our elders and people that have been, I feel, misled on this issue. So sovereignty does not mean the right to violate written tribal laws or operate unfair elections. So as demonstrated in that judicial review and upheld the written tribal election laws, which members voted on, the verdict prevented the SCN tribal laws from being reverse engineered to fit the board, as the judge said. So sovereignty does not mean the rights to override fair election law correctly and rewrite the rules after the fact to fit an agenda. So after the verdict came down, we see the statement from the chief to members on March 9th. My judgment was on March 8th, which falsely claimed that the verdict violated sovereignty. This reminds me actually of the Onion Lake chief who was found guilty of appropriating $36 million, which went missing from his ban. Then the Onion Lake chief turned around and told the First Nations and media that the First Nations Transparency Act, which the Onion Lake tribe wanted in order to track the appropriation somehow, violated the ban in chief's sovereignty, quote, violated, quote. So the day after I won the election law case, the chief issued the statement to the members online. That the federal court ruling in issuing its judicial review may be construed as disregarding the law of the Samson Cree Nation when it comes to how elections are held. So he continued to say the issues before Chief and Council is now based on individual, but the issue of sovereignty and inherent right to govern the SCN as supported by UNDRIP. Yeah, so I'd invite all the members to read the case online, and they'll see that it actually upheld our own written laws in Aboriginal law, including RCA, RCAP, and UNDRIP and Babalov. Also upheld administrative accountability. So I'd beware of the word salad to try and manufacture consent. So administrative accountability for unfair elections is an important part of tribal democracy. So there was an elders advisory on the election law committee formed back in that same time, March 2021, to address my judicial review. So it says here that it's a specific intent to address issues which stem from my case. Again, in the letter dated March 16th, Chief states that in response to directions provided through the motion of Senior Council, it's a responsibility to maintain an open line of communication regarding recent events in relation to the judge's decision around my judicial review. Now I'll say that I was actually not included in any of the changes to the election law as victor of the judicial review, and then the Chief's trying to say that make those statements around sovereignty actually false and misleading. So he also was able to affect the election law amendments due to my case, which reflects bias and undermines members' rights. So the proposed amendment sheet for election law changes states that many changes are due to my case. Yet some of those recommendations and changes are not being implemented in these proposed changes. So they're not being that's false and misleading as well. That they're following the judicial review recommendations. I haven't seen, I read it. I haven't seen any of those proposed changes. So yet the invitation to this meeting on election law changes states only that the Samson Cree Nation Elders Advisory Board bases proposed amendments on this feedback report questionnaire results 2018, which is misleading. Further, many of those 2018 poll questions were ambiguous and loaded questions. Using those poll results to justify many election law changes is unfair. For example, the polls asked members if they think Chief and Council should speak Cree. A yes answer does not fairly translate to 80% of SC members who does not speak Cree will be banned from running elections. The answer may have been much different. So the SCN tribal governments has a duty to uphold Aboriginal human rights, including fair elections without discrimination. So you should be aware of misleading language to generate manufactured consent, non-informed consent. I wasn't the only one that had questions around that questionnaire they're using, 2018. It's now approaching 2023 and it's could be outdated. I know as well that the election committee who was working on that last term, they did not complete their work, or they did, I don't know how many questionnaires or surveys were issued. I do recall working with the election law as a summer student 10 years ago. I want to say 2012, 2013. And we did like 4,000 surveys. I remember that was a lot of work. So we're just doing a lot of data entry, engaging with a lot of community members to see what proposed changes they would like to see, or amendments, or what would they like to see in our election law. I don't think that same bar was met around this questionnaire results, which they're basing a lot of them on. This was that specific purpose committee, the motion that was made, again, day after my judgment. Yeah, a lot went down around this time. I remember that was like If you recall, the chief had taken a few weeks off for personal reasons, appointed finance chair as the acting chief. I was called to this, quote, welcome back ceremony, end quote. For about 12 hours. It was a very long day. And I spoke with some of these, not all these elders were there. There was a couple elders now that were there who did not agree with what had happened. After that, after I met with the elders, we had a little, I'll call it a restorative justice circle. If you guys don't know what that is, it's basically when you set up a circle between two parties and you try to get for a crime committed and you try to get one party, the guilty party, to apologize to the victims or something. So they set up this circle, and then they're trying to force an apology for me. And I did not apologize. I actually just said that the whole thing was backwards, the way they were acting. And I should have received an apology along with my family for everything that had transpired throughout that whole process, because I was put in a position where, I had no choice to file a judicial review, because I was pretty much left in the dark, and there was just a lot of dirtiness that went around it. But yeah, that was what came out about that. Then there was a elders report in early April. Again, I was not privy to any of this information, but in this motion, my name's in this motion. So I should have been granted all that stuff, procedural fairness, natural justice, and I wasn't, which was kind of disappointing. So here we have the information session on October 24th from 12 to 4. The general meeting is being called on November 7th at 10 a.m. So contact SCN if you have any questions, 585-3793, extension 101. So last slide. So very informational. I hope you learned a lot. I know it was a lot to take in, but that's just the one issue and proposed amendments and everything else. So I've been sure that's one purpose they've had my page up, is to try to keep members informed and up to date on issues. I've been working to protect your informed consent from manufactured consent, and thus all chief and council members must continue to recognize that all SCN election law and the law must always uphold Aboriginal civil and human rights, including the right to fair elections for Aboriginal tribunals and the right to challenge our governments in the court of law. These are the basic rights of all Aboriginal Canadians. All right, well, I hope to see a lot of people out on November 7th. If not, I hope that I can see these either delayed or reviewed by a constitutional lawyer, so that we don't need our elections being delayed or anything. And we can just have an honest, fair, and equitable election for everyone. Okay, makes sense.